Welcome to For the Record with Greenwood Law.
Welcome to For the Record with Greenwood Law with attorney Dylan W. Greenwood, founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal court, known for his high-level personalized representation and hands-on approach to every case. I'm Shameika Rhymes, and today we're talking about how prosecutors decide whether to file or drop charges in North Carolina. Welcome back, Dylan.
Thanks for having me. Glad to be here.
Well, Dylan, before charges ever get filed, what is the prosecutor actually trying to determine in a case?
So I think it's important to make a distinction between state and federal charges. So at a federal level, the U.S. Attorney's Office, by and through their assistant U.S. attorneys, are very involved with investigations. They consult one-on-one throughout an investigation with their law enforcement agencies. So think FBI, DEA, Homeland Security, ATF, any of the federal agencies you can think of, and local agencies as well, because there's joint groups within those. And so they consult with them throughout. They can use grand juries to help further an investigation, to do kind of these preemptive questionings that occur. They can do different subpoenas and wiretaps and all these different things that really set them apart in that regard. State prosecutors are a little bit different. I would say state prosecutors at a certain level are involved in investigations, but not quite the same as federal prosecutors. A lot of times in those situations, a DA might be involved in the sense of helping get a search warrant, or talking to law enforcement officials potentially about wiretaps and maybe applying for one, or maybe an initial set of charges is filed against someone, and then because of that, there's this ongoing investigation, and then they're involved with it that way. But you also just have to bear in mind the numbers are different. There's a lot more state cases than there are federal cases, so that approach has to be different, because the time is a limited resource for anybody involved. But what a prosecutor is trying to determine is really at its core, is there probable cause to go after an arrest? That for an individual purpose, that is what they're looking for. Now, there might be an overarching drive and directive for an investigation or a case within an investigation. I mean, I've been a part of federal drug conspiracies that have had 40 and 50 people involved. And there is a goal in that sense to work your way up. You're trying to get to the top for that person that is the big supplier or the head of organization or whatever else. And so sometimes the directive or the goal ultimately is different depending upon what agency you're involved with.
Okay, that makes sense. So, what information is typically available at that early stage, and how complete or reliable is it?
So a lot of times, I would say the overwhelming majority of time, it is something that has just happened. Member of law enforcement, sheriff's deputy, police officer, they're calling up an on-duty prosecutor, and they're saying, hey, here's the overview of the facts that just happened. Here's what this person's doing. Here's what this witness is saying. Here, kind of run through the 30,000-foot view of it. And an on-duty prosecutor is going, okay, I think this is this, and this charge. This is what I think you should try to get a warrant for. And then that law enforcement official is going to a magistrate, explaining what's going on, and they're applying for a warrant for the particular set of charges. And then a magistrate is making an initial probable cause determination, or should be. I will say that there is usually a difference of opinion among different groups of people as to what probable cause is. I would say there's a difference among prosecutors as to what it is. There's a difference among magistrates as to what it is. And then judges have their own spectrum of what probable cause is. And that's really because, at the end of the day, every case is different, and you're trying to figure out within that specific case what it is that gets you over that edge.
So, how do law enforcement reports and initial narrative shape the way that a prosecutor first sees a case? And I know we just talked about, when police are wanting to talk to a witness, victim, or possible suspect, and that now that you've got all the information, how did those reports shape that?
Sure, I think it can shape it a couple of ways. One is I think it helps shape bond. So how how a prosecutor is either fighting for particular conditions of pretrial release or bond or not, because they're making a snap judgment as to the strength of their evidence. And that's really what it is. When they're reading these initial reports before they get everything back, it's a snap judgment call, about the strength of their case. Do they need more stuff? Do they need law enforcement to follow through on some sort of forensic evaluation or testing or what have you? And more often than not, they're going to be very candid with either myself or with a court and say, hey, this is the picture we have at the moment, but based off of what law enforcement is telling us, we're proceeding in this way. And so for that reason, those initial reports can be kind of important, because they are really directing the first moves of a prosecutor and what happens from then on out.
Well, how does the strength or weakness of that evidence influence whether a case moves forward?
So prosecutors are one of the um, they're one of the groups of people within the criminal justice system that assess probable cause. So prosecutors have an extra set of ethics that other attorneys don't. And part of that is to assess probable cause of a case. And you're supposed to look at the evidence and say, is there enough here to proceed? Do we feel like we can get across that benchmark? Now, I'm going to tell you right now, I have gone to many a prosecutor and I have told them, you do not have probable cause for this case because of whatever reason. And they've looked at me and they say, no, I feel like I've got enough to at least go to a hearing about it. So we're going to proceed. Every now and then, though, you go to somebody and they're like, yeah, I think you might be right. I don't know that there is probable cause. Or, I think law enforcement got a fact wrong. Or you have a situation where the initial report maybe got a prosecutor to think one way about a case. And then all of a sudden, once they get everything else, like the body worn camera footage or the testing from forensics or anything like that, they're looking at it and they're going, oh, no way. I can't proceed from then on out. So it is an ever evolving circumstance, and every case is different. But generally speaking, if cases are weak, sometimes it leads to a dismissal. Oftentimes it leads to a very favorable plea negotiation. If cases are very strong, then that can go the other way, where there isn't as much leeway. That's not a given rule, but it can certainly lead to that, or where it's, hey, you can either take the plea or take it to trial. It's your choice. That's kind of generally how it works out.
Well, so what role do witness credibility and conflicting accounts play in that decision making process?
I would say they play into it quite a bit, because a prosecutor is looking at, any attorney is, they're looking at a case with, if we go to trial, what's going to happen? So a DA is also, or a U.S. attorney is also looking at that very same thing. So they're trying to assess whether or not their alleged victims, the witnesses involved, are they going to show up? Are they going to be credible? How they're going to come across? What they're going to say? And so if a witness isn't credible for one reason or another, or they have conflicting accounts, they know that a competent defense attorney is going to swoop in and needle in on that during cross-examination and try to make their witness look like they're not giving credible information at a trial. And when you
Hmm.
play all that out, like I've mentioned before, prosecutors, like any human being on the face of this earth, only have a limited amount of time to do whatever they need to do in a given day, right? Time is a finite resource. So prosecutors have to do a triage
Mhm.
as to what cases make the cut to pursue for trial, which ones don't, and so on and so forth. The way that typically plays out, not all the time, but the way it typically plays out are the cases that are just locked in, locked tight. We know the evidence shows whatever outcome has been charged. This person's probably guilty of it. And those cases certainly happen. A lot of times those plead. The ones where the evidence is really weak, like they maybe just got across that threshold to be probable cause, but it's not nearly going to be the threshold to be beyond a reasonable doubt. A lot of times those get very favorable outcomes. Maybe conditional discharge offers are on the table, or somebody can work their way to a dismissal, or if it's a felony charge, all of a sudden it comes down to a very low misdemeanor, something like that. It's the cases in between where you don't quite know one way or the other. Those are
Mhm.
the ones that typically go to trial. And at that point, everybody's trying to assess credibility, what somebody's going to say, what we think somebody's going to say, and all that comes into play.
So, at what point does a case reach that threshold where charges are more likely to be filed?
Yeah, so at that point, it has to do with um, a lot of times with strength of the evidence, what someone says. At those early stages, what someone says has more to do with what pans out. Now, this is a this is also a spectrum. So when I think of this in
Mhm.
terms of, let's say there's a domestic violence call, police get called out for a domestic violence call, and you've got a witness, you've got an alleged victim, and they're saying, "Hey, this kind of thing happened." It may not be 100% congruent, but the gist of it is that, let's say someone got assaulted and injuries were observed. Most of the story is the same, but maybe you've got an accused individual saying, no, that never happened that way. More often than not, that's
Mhm.
probably going to lead to charges based off of just what people say. Now, different set of circumstances or different set of facts. Let's say you get into something like indecent liberties with a minor, any type of sexual assault allegation. More often than not, somebody is reporting that, and then an investigation is going to ensue. And usually, the more serious the case, the more involvement prosecutors have during that investigation to decide whether or not charges should be filed. I see that a lot of times in sex related cases, sexual assault, where there are these back and forth meetings that everybody has to say, hey, this is a he said, she said case. I don't know if it's worth going through with it. There seem to be a lot of outside circumstances that might have led to this, where maybe it caused someone to be biased or whatever else. But then there are cases where they go in and they say, listen, we've done all the forensic, we've pulled everything. This case is locked tight. We see that they had this, that, and whatever on their computer. They accessed it on these days. They, all this stuff. And then all of a sudden that is a much stronger case. And then usually a prosecutor is greenlighting those charges.
Well, in situations where a case does not move forward or it starts to fall apart, what tends to be driving that outcome?
I see that more often than not with witness availability, witness credibility, or some key piece of evidence falls through. So either, like, I had a case one time that the entire case fell through because the canine involved in the case died.
Oh,
Um,
goodness.
the so that case just it completely fell apart. I've had
Mhm.
cases where the laboratory messed up the chemical analysis of whatever they were looking at, and all of a sudden it tainted all the results. Case fell through. I mean, there's all sorts of ways in which that could possibly happen. Um, but a lot of times it comes down to some sort of key linchpin piece of evidence that all of a sudden
Mhm.
cannot be proven because some sort of way to provide it or to have it has fallen apart.
So, what practical pressures or constraints influence how prosecutors decide to proceed in real cases?
Oh, that is a loaded question. Um, that is a very nice way of saying that, yeah, uh, prosecutors are, they're politicians,
Hmm.
they are public figures, and they get criticized in the media. Very few times does a prosecutor get congratulated in the media. Their name's usually in the paper because something didn't go right. And that's a tough position to be in. That is not an enviable position
Right.
by any way, shape, or form. And so I think more often than not, district attorneys' offices in particular try to be mindful of the issues that are going on in the community, whatever societal pressures are, however that pans out for where you are located. And that's going to be different in a city like Winston-Salem versus a more rural
Hmm.
community somewhere else. And I think that those practical considerations can weigh into how quickly charges come about, what charges come about, and how hard a case is pushed to go to trial, or whether or not certain plea offers are even on the table. I have seen that pan out in my own career. I had a case in a more rural county that was a white collar case where my client had never been in trouble before, had come up with every single penny of the money at issue in the case. And typically speaking, in those types of cases, those cases can be figured out. When it is a lower level financial case, someone's never been in trouble, those cases could be figured out. There was so much outside
Wow.
pressure on this that I thought I was fighting a war just so that this person would not have a felony
Mhm.
conviction. And it was beyond me, what I was having to deal with. Ultimately, we ended up getting it figured out, but it was an absolute drag out fight. And that you, you can't ever disregard the outside practical pressure of what offices have to look at.
Wow, I had no idea. So this has been very helpful, Dylan, to learn how prosecutors decide whether or not to file or drop charges here in North Carolina. Thank you for breaking this down for us.
Yeah, you're very welcome. Happy to do it.
Well, that is it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about attorney Dylan Greenwood and his work at Greenwood Law, visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal cases. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.